right, so let's call the cases of for the state of Michigan versus Robert Boyd. It's two file numbers, 20-5979FH and 5980FH. We have Mr. Boyd present in the courtroom, as well as his attorney, Mr. Gilbert, and the prosecuting attorney, Ms. Goodrich. We're providing public access both in the courtroom and online. And Mr. Boyd, good afternoon and welcome to the courtroom. We're glad to bring you here in person.
Thank you, Your Honor.
All right, and we're here today, Mr. Gilbert, looks like on a docket call in both matters and also a bond violation hearing. And it looks like the, maybe we could address the bond violation hearing first. It's alleged that that he violated the conditions of bond by engaging in assaultive behavior toward somebody in the jail. I guess before we would proceed with any evidentiary hearing on that, I would entertain preliminary arguments from the attorneys about whether that's whether I could violate his bond for that since he's not posted bond. Ms. Goodrich?
And I know that we have had a similar argument before. They are put on the list of bond conditions at time of arraignment. That includes not having new crimes as a deterrent, even when in jail, to not acquire new crimes. And I would say that that still applies while incarcerated.
Okay, thank you. Mr. Gilbert?
Your Honor, in regards to that argument, that is exactly our argument. Mr. Boyd does not have a bond. That's the reason he's standing next to me today. He very much wishes he did have a bond, but he doesn't. And thus, when conditions are placed on called bond conditions, he has to abide by those if he posts a bond. So our argument is he never posted bond, so he cannot have a bond violation based off of any activity that he would have that violated those conditions because he didn't do it. Furthermore, the prosecution has a misdemeanor charge going against him. That's a punishment enough for that activity that did take place, regardless of the bond violation. Furthermore, since this has happened, my client has been incarcerated the whole time. I think he has the record now for being incarcerated in the Sheboygan County Jail the longest of any individual, based off of because of the issues with COVID. I believe the penalty of 93 days is long past gone. That he has already served that since this incident took place. But back to the original argument, our argument is that you can't have a bond violation if you don't have a bond. Thank you, Your Honor.
Well, and this has come up from time to time, mostly in the context of a violation of a no contact order. And I do believe that we had previously held Mr. Boyd in violation of that very thing, of contacting one of the complaining witnesses. And there are no published Court of Appeals cases or statutes or court rules that I'm aware of addressing that. There are some unpublished Court of Appeals decisions that I've relied on to enforce no contact provisions. So it's a little bit of a gray area, but I'm going to only enforce that with regard to no contact provisions because that's intended to protect a specific person. I think it would be a little too broad to hold a defendant liable for contempt for violating all the conditions of bond when they haven't posted the bond. And there's conditions, all the standard conditions that are usually with those. I understand the prosecutor's concern about, having a disincentive for criminal cases in the jail. And I think that's taken care of by existing statutes. As I understand the law, if Mr. Boyd were found to be guilty of having committed a crime while in the jail, that would be a mandatory consecutive sentence. So if he's let's say he's found guilty in the district court and the district judge gives him 93 days in jail, he doesn't have any credit for that yet because it's mandatory consecutive. Whereas I've got him in jail on no bond in one of the cases. Bond has been revoked. I've denied his repeated motions to release him on bond. So practically, there's not a lot I can do anyway, and I think that would stretch the stretch the situation too far. So I'll find, I guess I'll grant what I expect is the defense motion to dismiss the show cause. I would grant that and dismiss that show cause in both files.
Thank you, Your Honor.
Thank you.
All right, and in terms of the docket call, Mr. Gilbert, are these cases ready to proceed for trial?
They are, Your Honor. We'd like a date.
All right, and we had previously discussed that we would go with file 5980 first. And how many days do you think you would need, including jury selection? Would 3 days suffice?
Your Honor, I believe that would be appropriate. When we first gave the number of days, I believe we were taking into consideration the COVID lockdown, and that we would have to move jurors in and out of the room and downstairs, and that would just take up a considerable amount of time. In this case, I think 3 days would be sufficient.
Ms. Goodrich?
I would agree.
Okay. All right, Mr. Boyd, we are, we have the green light from the state to schedule jury trials now. And so we are giving dates. And so I'm going to give you some trial dates right now that are going to be firm dates. These are the dates we're going to go. Okay. People can subpoena all their witnesses and we're going to go on those dates. Because we have to find a 3-day chunk of time, it takes a little bit longer to find that many days in a row. So you're not going to love when it is. It's going to be Wednesday, October 6th, and Thursday the 7th, and Friday the 8th. So that's the soonest, looking at the calendar, that I can give you 3 contiguous days that aren't already claimed. But those will be your days. We're not going to schedule it. It'll happen those days. Okay.
Yes, Your Honor.
So we'll schedule jury selection and trial for Wednesday, October 6th through Friday the 8th. No adjournments will be granted except on good cause. Have trial witness and exhibit lists already been exchanged?
Your Honor, my exhibit list, it's only one additional name other than my client, and that will be to the prosecutor's desk.
Well, I'll give you, I mean, the trial's in 3 months, almost 3 months. So I'll give you 14 days to file final witness and exhibit lists.
Thank you, Your Honor.
And I'm going to say jury instructions will be due. It looks like you and I, Mr. Gilbert, are in the Pettit trial the week before. So just so that.
Your Honor, the trial's no longer mine.
Oh, that's right. That's right. Okay, well, I'm going to be in. So I'm going to order that proposed jury instructions would be submitted by Friday, September 24th. Are there any additional pretrial motions that the parties anticipate or no?
I don't believe so, Your Honor.
Not this time.
Okay. So there's no need to set for a docket call?
No, Your Honor.
All right, so we're going to schedule this in file 5980 for a jury selection and trial beginning Wednesday, October 6th. And in file 5979, I'll continue a docket call to October 6th. We'll just so there's something in the calendar at October 6th at 9 a.m. That's just so that the cases can track together. And the jury selection will begin at 9 a.m. We'll summon the jurors to report here for 8:30. And Mr. Gilbert, you'll ensure that Mr. Boyd has street clothes.
Absolutely.
Okay. Your Honor, did you say 5979 or 5980?
5980 is the one that's going.
Okay.
That's the one with the
Okay.
felony firearm charge and. All right, anything further, Mr. Gilbert?
No, Your Honor, thank you very much.
Ms. Goodrich?
No, thank you.
Okay, Mr. Boyd, I'm sorry I can't give you sooner dates, but at least I can give you dates.
Yes, Your Honor.
Okay, have a good day. We're gonna go off the record for a minute. Morning, Ms. LaFleche. What case are you here on this morning?
Good morning, Amanda Pad.
Okay, well, you're in luck because that's the case we're calling.
Great.
From page 5, People versus Amanda Pad, file 20-93159FH. We have defense counsel and the prosecutor present in the courtroom, supervising agent on Zoom. We're providing public access both online and in the courtroom. We're here today for a status conference and a show cause hearing for Ms. Pod, who's had a medical furlough from the jail, and it's alleged that she's not complying with her occupational therapy, and that's been terminated, and the hearing is to determine when is it time for her to return to the jail. She was ordered to be here in person, and she's not here. Mr. Vogler, do you have any information about her whereabouts?
I don't, Your Honor.
Ms. LaFleche, do you have any information in terms of an update of her medical situation or suitability for return to serve her sentence?
I do not, she has not provided me any documentation. I've had contact with her and she knew about today's court date.
Okay. Mr. Radzivon, any requests from the people?
Yes, Your Honor, we'd ask that a pickup order be issued by this court. Judge, I did receive a discharge summary form that was electronically signed June 7th of this year. According to this, she has completed her physical therapy. And while they do recommend skilled home physical therapy, it's our position she could go ahead and return to jail. I don't see the need to continue referral medically at this time.
Well, and what I'll do is I would issue a bench warrant for Ms. Pad's arrest with no bond for contempt of court for not appearing today. And then I guess when she's picked up on that, we'll arraign her on that and then address whether she's to serve her remaining sentence at that point. All right, have a good day, Agent LaFleche.
Thank you, you too.
All right, Mr. Martin, can you hear us?
Yeah, again.
All right, so this is from page 6. People of the State of Michigan versus Daryl Martin. It's 2 files, 19-93070 is just a probation violation file tagging along. The violation is an alleged new crime. That's the new file 20-93153FC. We're scheduled for jury trial to begin with jury selection a week from this coming Friday at the Bismarck Township Hall. And then the trial be continuing the following Wednesday through Friday. We have Mr. Martin present from the Prescott County Jail by Zoom video. His attorney, Mr. Vogler's in the courtroom, as is the prosecuting attorney, Mr. Radzivon. And the complaining witness's mother is present in the Zoom hearing as well. And counsel, the courtroom is open. It's a public hearing. We are also providing enhanced public access online. As I understand, the motion today is for witness accommodations and would require the testimony from a counselor and detailed testimony about a minor witness's state of mental health. Is that correct, Mr. Radzivon?
Right.
All right, so I would propose that we terminate the live stream, and it is still an open courtroom, but we not live stream this hearing. Any objections?
No.
All right, so we'll go ahead and terminate that live stream. -5975FH. We have Ms. Panicali appearing by Zoom video. Her attorney, Mr. Gilbert's in the courtroom, as is the prosecuting attorney, Ms. Goodrich. We're here today for a docket call and also a bond violation hearing on a pending OWI charge down in district court and a show cause for some missed tests. We are providing public access both here and in the courtroom. And Ms. Panicali, I guess first I'll advise you that I did speak with the prosecutor and the defense attorney with regard to the testing issue. And based upon information I was provided that you are testing, I'm going to dismiss that show cause at this time.
Thank you, Your Honor.
All right, so Mr. Gilbert, we're here for docket call.
Yes, we are, Your Honor, and I spoke with the prosecutor, and we've come up with a new plea agreement. I've also discussed this matter with Ms. Panicali, and she wishes to accept this plea at this time, if I may approach.
You may.
I also provided her I signed a copy for her, but she has been provided with a copy of her advice of rights.
Okay. And Ms. Panicali, do you wish to enter a plea according to the terms of this agreement?
Yes, I do.
Would you please raise your right hand?
My bad.
Fine. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Would you state your name for the record, please?
Amanda Renee Panicali.
Ms. Panicali, a guilty plea hearing is an important event because it includes you waiving important constitutional rights that you have. So listen very carefully. At any time, if you need to speak with your attorney some more, you just ask us and we'll make that happen. Do you understand that?
I do. Thank you.
All right, now you're offering to plead guilty to count 1, which is a charge of
We are bringing an amended, Your Honor, to remove the double.
Is count 1, unless I'm missing an amended information, it looks like it was a conspiracy to deliver?
Yes, please, so Judge.
Yes, it would be an amended count 1. Remember, that wasn't an offense. In effect, it is conspiracy.
Okay, do we have an amended coming or?
Ms. Patel's working on it right now.
Okay, all right. And so, Mr. Gilbert, do you consent to the filing of an amended information changing count 1 from a conspiracy to a delivery?
Yes, Your Honor, that was the agreement. Thank you.
Okay. All right, so Ms. Panicali, you're offering to plead guilty to a charge in an amended information to be filed today to a charge of delivery of the controlled substance Suboxone or buprenorphine. That is a felony crime. It's punishable by up to 7 years in prison and or what's the fine on that? Because on the information I have, it's the conspiracy fine. All right, maybe we should pass this case. All right, Ms. Panicali, I'm going to have to place you back in the waiting room while we get the paperwork straightened out because I don't have an information that has the proper charges on it.
All righty.
All right.
Okay.